everyone, my name is Halia. So today we'll be discussing about consumer protection. So what is consumer protection? Consumer protection is the totality of regulations and law that regulates the rights and obligation of consumers and producers that arise in the efforts to meet their needs and regulate efforts to ensure the realization of legal protection for consumer interests. These can be all buying and selling transactions, directly or online, as is now increasingly common. Even though transactions are not face-to-face, consumers still have the rights to receive goods that comply with prior notification and goods that they have already been promised.
Moving on, what is the legal basis for consumer protection in Indonesia? Consumer protection law is regulated in Law Number 8 of 1999 concerning consumer protection. This is an important step in providing protection and rights for consumers in Indonesia. According to Article 1 of the Consumer Protection Law about general provision, consumer protection is any effort that ensures legal certainty to provide protection consumers. Consumers are every person who uses goods or services available in society, whether for the benefit of themselves, their family, other people, or other living creatures, and not for trading. Business actor is any individual or business entity, whether in the form of a legal entity or non-legal entity, which is established or carries out activity within the jurisdiction of the Republic of Indonesia, either individually or jointly through an agreement to carry out business activities in various economic fields.
For the consumer protection purposes, as stated in Article 3 of the Consumer Protection Law, the first is to increase the consumer's ability, awareness, and independence to protect themselves. Second is to raise the dignity of the customer by preventing them from the negative excesses in the use of goods or services. The third one is to raise the consumer's empowerment in choosing, determining, and demanding their rights as consumers. Fourth is creating a consumer protection system that contains the elements of legal certainty and information disclosure as well as access to information. Fifth is to increase the awareness of business actors regarding the importance of consumer protection so that an honest and responsible attitude in business can develop. And the last one is improving the quality of goods or services, which ensures the continuity of business production of goods or services, health, comfort, security, and safety of consumers.
Legal protection for consumers is carried out as a joint effort based on 5 principles, and the legal principles of the consumer protection are included in Article 2 of the Consumer Protection Law, namely the principle of benefit, namely to mandate that all efforts in implementing consumer legal protection must provide the maximum benefit for the interests of consumers and business actors as a whole. The principle of justice aims to ensure that the participation of all people can be realized optimally and provide opportunities for consumers and business actors to obtain their rights as well as carry out their obligations fairly. The principles of justice also requires that through consumer protection legal regulations, consumers and producers can act fairly by obtaining their rights and obligations. Therefore, the Consumer Protection Law regulates the rights and obligations of consumers and business actors. The principle of balance is a principle to provide balance between the interests of consumers, business actors, and the government. This means that the interests of consumers, business actors, and the government are regulated and must be realized in a balanced manner, in accordance with their respective rights and obligations in the life of the nation and state. The principle of consumer security and safety is intended to provide guarantees for security and safety to consumers in the use and utilization of the goods and services used. This means that there is a legal guarantee that the consumers will benefit from the products used and the products will not threaten consumer safety. The principle of legal certainty which aims to ensure that business actors and consumers obey the law and obtain justice in implementing consumer legal protection. Then, in this case, the state also guarantees legal certainty.
Is there an institution capable of handling consumer protection issues? If so, what consumer protection institutions are known in Indonesia? There are 3 consumer protection institutions in Indonesia. First, based on Article 1, Paragraph 12 of the Consumer Protection Law, the Consumer Protection Agency, or BPKN, is a body to establish to assist effort to develop consumer protection. BPKN was formed in order to develop consumer protection efforts and has the function of providing advice, consideration to the government in efforts to develop consumer protection in Indonesia. The second one, non-governmental consumer protection institution, or LPKSM, are regulated in Article 1, Paragraph 9 of the Consumer Protection Law. Only a non-governmental organization registered and recognized by the government which has activities dealing with consumer protection. The government recognition of LPKSM is not unconditional, meaning that the institution must be registered with the district or city government and operate in the field of consumer protection. The registration is only intended as a record and not a permit. And the last one, Article 1, Paragraph 11 of the Consumer Protection Law defines the Consumer Dispute Resolution Agency, or BPSK, namely a body with tasked with handling and resolving disputes between business actors and consumers. Every consumer who is disadvantaged or involved in a dispute can resolve the dispute through general court institution. Settlement of consumer dispute through this court refers to the applicable provision of general justice. By considering the provision of Article 45 of the Consumer Protection Law, apart from being able to resolve a consumer dispute, it can also be resolved outside of court via BPSK. If an effort to resolve a consumer dispute outside of court has been chosen, a lawsuit through court can only be made or pursued if the efforts are declared unsuccessfully by one of the parties or the parties to the dispute. Settlement of dispute outside of the court through BPSK does not eliminate criminal responsibility as regulated in the law. Article 45, Paragraph 3 and Paragraph 4 of the Consumer Protection Law.
What sanction will you face if you break the law?
Refer to Article 60 to Article 63 of the Consumer Protection Law, strict sanction against business actors concerning consumer protection in the form of administrative sanction, imprisonment, and fines. In Article 60 contains the Consumer Perpetrator Settlement body has the authority to impose administrative sanction on business that violate Article 19, Paragraph 2 and Paragraph 3, Article 20, Article 25, and Article 26. Administrative sanction in the form of compensation of maximum of 200 million rupiah. Procedure for imposing administrative sanction as intended in Paragraph 1 are future regulated in statutory regulation. Criminal sanction in Article 61 contain that criminal prosecution can be carried out against business actors on their management. Article 62 contains business actors who violate the provision as intended in Article 8, Article 9, Article 10, Article 13, Paragraph 2, Article 15, Article 17, Paragraph 1, letter A, letter B, letter C, letter E, Paragraph 2, and Article 18 shall be punished with a maximum imprisonment of 5 years or a maximum fine of 2 billion rupiah. Business actors who violate the provision as intended in Article 11, Article 12, Article 13, Paragraph 1, Article 14, Article 16, and Article 17, Paragraph 1, letter D and letter F shall be punished with imprisonment for a maximum of 2 years or a maximum fine 500 million rupiah. For violation that result in serious injury, serious illness, permanent disability, or death, applicable criminal provision apply. And Article 63 for criminal sanction as intended in Article 62, additional penalties may be imposed in the form of 1. Confiscation of certain goods. 2. Announcement of the judge's decision. 3. Payment of compensation. 4. Orders to stop certain activities that cause consumer losses. 5. Obligation to withdraw goods from circulation or revocation of business license.
Next, we will provide examples of cases related to consumer protection violations.
Today we will be discussing about the case of alleged use of second-hand rapid test tools in Kuala Namu International Airport, Medan.
North Sumatra Regional Police Special Criminal Investigation Directorate arrested 4 officers of Kimia Pharma's rapid test service on April 27, 2021 at Kuala Namu Airport, Medan. The 4 are suspected of using used COVID-19 antigen rapid test kits for all potential passengers. They were Sepipa Raji and Depi Zaya, each sentenced to 2.6 years in prison. Then Marjuki and Renaldio were sentenced to 5 years in prison. They are also burdened with paying a fine of Indonesia rupiah 1 billion each, a subsidiary of 1 year in prison.
The former manager of Kimia Pharma Diagnostika Pikandi Maskojaya underwent a verdict trial in the case of a used antigen test at Kuala Namu International Airport, Medan, was sentenced to 10 years in prison. Apart from the criminal sentence, Pikandi also received an additional penalty, namely a fine of Indonesian rupiah 1 billion, provided that if the fine is not paid, it will be replaced by imprisonment for 1 year. He was charged with violating the Health and Consumer Protection Law. Pikandi has violated Law No. 8 of 1999 concerning consumer protection, Article 8, Paragraph 1, which states business actors are prohibited from producing and or trading goods and or services that A. Does not meet or is not in accordance with the required standards and provisions of laws and regulations. B. Does not correspond to the net weight, net or net contents, and the calculated quantity as stated on the label or label of the goods. C. Does not match the measurements, measures, scales, and quantities in calculations according to actual measurements. D. Does not comply with the conditions, guarantees, privileges, or efficacy as stated in the label or description of the goods and or services. E. Does not comply with the quality, grade, composition, processing process, style, mode, or specific use as stated in the label or description of the goods and or services. F. Does not comply with the promise stated in the label, description, advertisement, or sales promotion of the goods and or services. G. Does not include an expiry date or the best use or utilization period for certain goods. H. Does not follow the provisions for halal production as stated in the halal statement on the label. I. Do not put labels or make descriptions of goods that contains the name of the goods, size, net or net weight or content, compositions, instruction for use, date of manufacture, side effects, name and website of the business actor, and other information for use which according to the provisions must be attached or created. J. Does not include information and or instructions for using the goods in Indonesian in accordance with the provisions of applicable laws and regulations.
Pikandi is considered to have deliberately ordered his employees to use medical equipment that does not meet standards, namely the use of used corona antigen test kits. Use of used antigen test kit is carried out in the laboratory at Kuala Namu Airport. The used antigen test kit is said to have been used from December 18, 2020 to April 17, 2021. For this action, Pikandi is said to have made a profit of Indonesia rupiah 2.2 billion.
To prevent the same incident from happening, Bio Farma as the BUMN Pharmaceutical Holding will strengthen services through digital and cashless transaction applications. The company's steps are also supported by the Ministry of Health, Ministry of BUMN, and the Financial and Development Supervisory Agency. to supervise the implementation of rapid antigen tests and national vaccinations. Furthermore, strengthening the internal audit system to ensure that all standard operating procedures in these cases can be managed properly.
President Director of PT Kimia Farma Diagnostika KFD Adil Fadila Burkini said that his party had improved the system so that use rapid antigen incidents like in Kuala Namu would not happen again. Starting from organizational restructuring, including improving morals, improving the quality of internal audits, to customer education.
So that's all for consumer protection. Hope you guys can learn it from the video. Thank you. Bye bye.